Hey, welcome everyone to Experts in Family Law Direct Examination. This is a program that we're kicking off, a series of programs that Peter and I are doing for the firm. And so welcome everyone. We are going to be spending a really deep dive on expert witnesses, and particularly on direct. These are expensive witnesses that are a crucial part of our case. And we tend to focus most on the cross-examination of experts and not the direct, but we win cases through direct, we lose them through cross. So this whole hour is going to be spent just on direct. Now, the opinion only counts if it gets into evidence. So we're going to be spending a ton of time talking about the objections that could be done, how to survive those, how to get this evidence in and to be effective with it. I'm introducing Peter Walzer, my partner, who's my co-presenter for this program. And if we haven't met, my name is Chris Melcher. I'm a divorce attorney here in Los Angeles doing trial and appellate work. Peter?
So experts are tricky. You got to know their role from the start. Are they going to be testifying or consulting? And why is this important? It's so important because if they are going to be testifying, every communication you have with that expert will be discoverable. So you better know that from the start. And it really doesn't work to say this expert is going to be consulting, then I'm going to convert them to be my testifying expert later. Because generally the ruling of the courts is that all communications, whatever time period they are going to be discoverable. And you've got to warn the experts. Often they forget, they get casual, they'll send you an email, what do you need, and so on. All communications have to be via Zoom, in person, or by telephone. And you just really need to keep to that rule. Unless you want it to be discoverable, and you usually don't. Keep a record of the communications because they're going to be requested later. You can't, and you've got to turn them over. Found out you're not turning them over, you could basically lose your case on that. So be very careful with that.
Now, when we're doing these assignments, there's going to be hard facts that the expert can rely upon, but there's also going to be some assumptions. And because not all the facts we're going to know, or some of the facts are in dispute. So that's something that I think about quite a bit. I also do some expert witness work in standard of care cases. So I'm looking at what are the assumptions that I'm making. And so I think a good expert would want to know that, and you want to make it clear. Hey, expert, are you making any assumptions in forming this opinion? What are those assumptions? Why are you making them? And if you're going to make the assumption that's favorable to our side of the case, what would change about your opinion if you made the opposite assumption? And so that's something to think about, because that could be devastating on cross and basically converting your expert into their expert to say, hey, I want you to now, expert, to make the opposite assumption. What is your opinion? Well, of course, it might go flip completely over to their side of the case, and that's all they need. There's also, I like to manage the experts carefully for cost reasons. And so what are we telling them to do? And just as important, what are we telling them not to do? So to be very clear about what that assignment is. Some experts know a lot of stuff and want to be helpful in other parts of the case, but I like to, control what exactly are we going to do. Now, when we deal with forensic accountants, we have some folks that are very knowledgeable. Two of them on this call, Jack Zuckerman and Jim Schaefer, just incredible forensics, and really is a testament to how good they are. They're attending this program. And so they know the law really well. Some of these experts know it as good as we do. But I'm not hiring them for that. I'm hiring them for their own particular expertise. And so I like to know what the law is on characterization, tracing, reimbursement issues, and then to direct them into that case. I think what happens with some of us is that we rely a little bit too much on the experts for everything. So I think we're the captain of the ship. We need to lead that. And some experts have different methods or views of what the law is or should be. And so we want to explore that and understand that. But ultimately, if we're saying, hey, this is our view of the world and this is how we would like you to do this assignment, we need to talk that out. And they could say on the stand, you know, yes, Mr. Melcher or Mr. Walzer told me to do the Pereira calculation this way, and that's why I did it. Draft reports. Now, the thing is that we're dealing with an expert in litigation. They're in a forensic capacity. And so I believe when you're acting in that role in litigation, you have a responsibility to keep a file and have some paper trail here. So there's accountability, and we know what drafts were exchanged and with the hiring counsel. And so you could be subject to discovery. We see some experts trying to avoid that by writing over the draft. So they have a big Excel spreadsheet and they make changes to it and they write over it. And when I do electronic discovery, I say, give me your Excels. I get one file. And it's like, how's that possible? You had 10 drafts of this. Well, I saved over it. I think that that's wrong. I think that's a way of avoiding discovery, and I would call them out on credibility for that. Sure, if it's an internal draft, but if that thing's shared, I think that each one should be saved. But, you know, and to that point, so some of these we want to do over the phone because maybe we're not ready to commit that to writing.
As you know, most of our cases end up in mediation at some point, and the forensics are a key part of our mediation. But make sure any reports they do or hand over in mediation are marked mediation confidentiality, or even settlement offers that might go back and forth. They're all marked so they can't later be used to cross-examine your expert. Mediation is often done early in the case. Trial is at the end. Opinions can change, and you don't want this to be a trap in your case. So make sure everything's marked, kept in separate files, and very clear as to what you're doing.
So, go ahead, Peter.
Often we give authority to the expert to sit down with the other expert to forensics. They may want to make a deal. They may feel they know the numbers better than you do. They may have an opinion to get this done. But first of all, the client has not given them authority to make that deal. And there may be many other considerations from emotional to tactical that deal should not be made. Got to be careful about what is done, whether you're with a private judge or a mediator. Be careful how that settlement is handled and make sure that you are working carefully with the expert so they know what they can and cannot do in the settlement context.
So we're going to end up having a deposition of an expert, and that's you know, pretty typical. And so a couple points on this is we want to make sure that that expert knows that they have to get all their opinions out there in that deposition. That's the purpose of expert witness discovery. And so that's where I'm clear in preparation. Hey, what are all your opinions? And if you have 3, let's drill those in. Hey, I got 3 opinions and maybe I have 2 sub-opinions under each one, whatever it is. But we want to know cold, what are your opinions? Because at the end, if it's a well-done deposition, they're going to do the lock, which is, hey, I've taken your deposition. Have you expressed all the opinions that you've rendered in this action? And if they say yes, and they try and then later come up with new opinions, those could be excluded. So that's super important for the expert to understand that we need that out there in this. The little trick here is videotaping your own expert's depo. When I started, I was in civil litigation doing personal injury cases, and I didn't have much of a budget. And so I'd hire an expert, and the defense would take my expert's depo, and I would bring along a videographer, because in the Discovery Act, it says that the videotape deposition of an expert can be used at trial for any purpose, even if the expert is unavailable. So you don't have to prove unavailability. So when I get the expert witness DEPO notice of my expert, I would return back a notice of intent to video under that code section and bring my own videographer. And now I have a video of that testimony. Now I could use that if maybe we run out of funds and we don't have the budget to bring the expert in. Maybe the expert gets sick. Maybe the expert's unavailable, which a lot of these folks are very busy. So now I have that in the can, ready to go, and it's locked. 7-hour rule doesn't apply to experts. Just another little factoid there.
So what you want to do is do a mock examination with your expert to see how knowledgeable they are about their own exhibits, whether they can explain their exhibits in a simple enough fashion that anybody could understand it. And you want to put pressure on them. You want to cross-examine them. You want to make them cry if you can. And if they're going to cry, you may not want to use them. Have your client present so they understand they're paying a lot of money for this expert and they should be involved in the process. By having the client there, if the client doesn't understand their explanation, then you've got to make it simple. Also, the exhibits can be very complicated in psychological report or a Excel spreadsheets or DISO masters. They've got to be clear and simple with no errors. One error in an Excel spreadsheet creates, all the numbers can be wrong. So you've got to make sure you can go over it, that they're clear enough to understand and that you understand them. So if there is a cross-examination, you can rehabilitate them quickly.
And yeah, and there's nothing wrong with a good cry every once in a while, so I wouldn't hold that against them. I think that the thing on the exhibits is hard, especially in these financial ones where they're very technical, or you may have sub schedules that feed up to a master schedule. So for me, I'd want a really working knowledge of that. I go line by line and I say, stop, I don't understand that line. Certainly the footnotes is where the action's at, so we want to study those too. But we need to understand that, so when we have the expert on direct, we can help them explain those exhibits rather than saying like, wow, okay, so you have some 500-page Excel sheet. Did you do that? Yes, that's mine. Move on. That's not effective. So really working that through so the court could see it and understand it.
So it's very important the expert is on board with you and they understand the full trial process and explain that things don't always go according to plan. They may be called at any time and they should be ready because, as we'll talk about later, the scheduling is sometimes not in your control. You don't want them to bring in new exhibits or opinion. If they change their mind or if they have a different take on it or they've revised it, you're going to have to give notice to the other side and make sure they have another opportunity to take the deposition of your expert. And that has to be very clear to the expert. Their testimony is useless if they change it and they don't tell you and you don't have a chance to tell the other side. No last minute changes. Even if there are mistakes, you can't change it. So anything they do is subject to examination by the other side, and anything they have with them. If they have that in the briefcase and they put some notes in front of them, as we all know, the other side can ask to see those notes and cross-examine them. Of course, we've got a huge problem with Zoom trials, virtual trials. How do you know what they're reading? Can you ask them to take a screenshot of what's in front of them? How do you know they're not looking at notes on another screen? All this is new territory, but you have to be aware of it, and you can always ask them, are you looking at anything? And generally, you can tell if somebody's looking at something. What are you looking at? Oh, nothing, an email. Well, that could look bad for them. So be careful how they're handling this. Make sure your expert knows their material and in theory can do it without notes. If they can't, make sure the notes can be handed over to the other side if necessary.
So this direct exam, like I said at the beginning, gets a little attention because people are fearful of cross. And so when an expert is preparing to testify, I think they tend to be anxious and they're worried about the cross. They don't want to look bad. And so they focus so much on that, and they haven't spent any time on direct. And it's really, again, through direct that we win cases. So I would rather spend all the time on or 90% of the time on direct and just a little bit on cross, because if you're well prepared on direct, we don't have much to worry about on cross. Now, I don't write questions down just generally. That's just not the way I operate. I'm more an outline or kind of in my head kind of lawyer. But if you're the one that writes these questions out really in detail, which is a good practice, I wouldn't give them to the expert. There's a huge discovery problem, obviously, with that. So if you've done that, you might find out or find the other side getting a copy of it through discovery. Also, it kind of ruins the moment a little bit. So we want this to be dynamic and fresh. And if it's too rehearsed, it just never comes out as good as it did the first time when you practiced it. So I would try and keep it more conversational and not give them the list of questions in advance. Now, of course, there are some really important questions with an expert that they have to acknowledge, and it may even be a leading question, and it has to be phrased a particular way. So if you have that type of situation, for sure, you're going to go through and say, look, expert, I need you to say yes if you agree with this statement and to get my case proven. So that's it. Anticipating the cross, obviously, if there's any bad facts or history with that expert, we want to understand that and maybe bring that out ourselves rather than having it done on cross when we don't have control. The other thing is that knowing the expert should know how their case, how their testimony fits within our case. And that's super important because we can't just assume that they know all that stuff. So I saying like, hey, expert, this is really important. You're here just on compensation issue, and this is how you fit in, and this is where it's really important, and here's the schedule of my forensic accountant where they took your number and plugged it in. So you know, this is super critical to me, so they understand where they fit in. Now, these experts are part of our story, and they need to be one of the storytellers. And that's what a trial or hearing is we're telling a story. That's what makes it compelling or persuasive. But expert testimony can be boring and dry because it's technical. So the role of the expert is to make what is complex simple, to make it understandable. But if you're talking to an expert and you don't understand what they're saying, that doesn't work. You might think, wow, this person's really smart because I have no idea what they're talking about. Sure, but we're trying to convince a court of something they need, that judicial officer needs to understand it. I remember a case that Peter and I did. It was actually the Valley case that we were trying together, and we had in one of the 3 phases of trial an actuary on the stand. And Peter was trying to get this testimony out of the actuary, and it was not understandable. And Peter said, look, just explain it as if you were talking to a 5-year-old. And I remember Judge Uhas kind of looked up at me and saying, well, what does that suggest? But still, he was trying to get it to say, look, you got to dumb this down and put it in English. This is a slide.
Is a teacher and can really explain it to the judge, explain it to the parties, and really is animated about it and is looking directly at the judge, and it's helpful to the judge. If they're adversarial or they're defensive, it's not going to help the judge. If they're really explaining it to the judge, that's what the judge is looking for, somebody to make it understandable, and that's what our best experts can do.
So this is a slide courtesy of Jim Schaefer, who's a forensic accountant who's with us today. And what he's done here is just really, to me, I like this slide, and he allowed me to use it. It's first of all, you need to learn the facts as an expert. So that's our responsibility, is to give the expert all the facts and to make sure that they understand them and to quiz them about it and make sure that they've done their homework. And so once the expert understands what those facts are, they're applying their skill and training to that to then form an opinion and put it in a way that's understandable. And so that has to be all synthesized. And rather than just focusing on, oh, what are your qualifications, or, oh, here's the facts, or, oh, what's your opinion? How are we going to get this out in a way that sells? And if we can't understand it, we can't sell it.
So all the plans may be out the window because your expert may be available at a certain time and you're going to present that expert. And usually the judges want to have the experts out of the way for convenience. And the judge can do that under Evidence Code 320. They set the order of proof. Of course, Code of Civil Procedure 607 lays out the proof as we know it, where it starts with the opening statement, starts with the petitioner, follows with the respondent, and so forth. But that doesn't often happen in a trial where you have all the scheduling problems. But if you do have the choice, you got to look at how they're going to fit in your story. You want to build to them. You want to lay out all the testimony so you get it into evidence that they're going to rely on. And we'll talk more about the Sanchez problem, or the so-called Sanchez problem, later. But it would be better to get everything out into evidence, all your exhibits admitted, and then follow with the expert. But it may not happen. In one case Chris and I were handling, the other side tried to call our expert under 776, but 776 does not apply to experts. It's only a party or person identified with a party, which means officers, directors of a party, that can be called under 776. So don't fall for that trick. But again, you'd like your case to go in a certain fashion, but it may not, and you're going to have to be flexible and nimble as to when you get your expert in.
So in that case, we were in trial, and it was Mark Kaplan who we're trying to case against, and we had our expert Terry Hargrave, a forensic, there. It was right at the beginning of trial, and we were the respondent, and Mark was representing the petitioner, and he saw Terry in the wings, and he says, "I'm calling Terry Hargrave under 776." There was another attorney I knew in the audience, and he came up and whispered to me, "Hey, 776 doesn't apply." And I said, "Huh, interesting. I hadn't thought about that, but watch this." "No problem, Your Honor. Go ahead." And Terry came on and testified and took control of the case. And she was very well prepared, fortunately, to go on the stand day one. And, hey, tactically, that could have worked out really, really well for the other side. Fortunately, Terry was a great witness, and she was prepared. And, hey, start off the case with my witness, no problem. So I'm not a big fan of 776 for that reason, but it doesn't apply technically.
So qualifications, you want to start with that. It may not work out that way. The judge may be impatient, want to get to the meat of the testimony, may say, will you stipulate to the qualifications? Well, be careful before you do that, because you want to build up to the story and show this person is the most knowledgeable person in the courtroom and can assist the judge. And take your time with it. Explain why this person is an expert, or let them explain why they're an expert. Don't be rushed about it. You may have to skip where they went to college or where they went to business school, and that's not so important. But as to how many times they've testified could be very critical. If they've testified on characterization, they've lectured on characterization, they've lectured on tracing. All these are very important to lead up to their credibility to the court. What about admitting their CV into evidence? It would seem like that's hearsay, But most judges allow that. What do you think on that, Chris?
Yeah, I mean, most people put it in. I don't think it adds anything. I don't know that the judge goes and studies it. You know, I am very careful about what I admit into evidence. I know Garrett Daly's got a saying, in for a penny, in for a pound. And when we do appeals, hey, if it was in the record, even though it wasn't talked about, if that exhibit got into evidence, it's fair game on appeal, and it may prove something. So I'm not a fan. I don't put them in because I don't care about their resume. And I want to know what makes them an expert. If they're a frequent flyer, somebody who's in court a lot, you know, like a Jack Zuckerman, you know, he's very well known. Jared Tonks, I also see here. You know, these are well-known folks. And so we're not going to go like, oh, where did you go to college? We don't care about that stuff. But if we were doing, for example, valuation of a restaurant, I'm going to drive right in there. Hey, have you ever valued a restaurant before? How many restaurants? Has it been in this area? What type of food? Is that a franchise, a chain, mom and pop? Spend a couple minutes on those qualifications. That's going to set them apart from the other experts. Say, well, you know, I've eaten at a lot of restaurants before, but I've never valued one. So I just dive right into the critical point and forget where they went to college.
And really that can come out on cross, is you've got to know your expert, or on voir dire, because at any time you could say, Your Honor, I'd like to voir dire this expert. How many restaurants have you appraised? Have you appraised franchises? What experience do you have in franchises? So the voir dire can be critical and can be interesting, and the judge may take it on themselves to voir dire your own witness. So they've got to be prepared for that and be very comfortable that they're testifying on something that they know. If it's an arcane subject, you may bring in a subject expert. One of the most famous voir dires of an expert was done. It was very effective. Chris, do you want to show that voir dire?
Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a 4-barrel carburetor?
It's a bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
Because Chevy didn't make a 327 in 55. The 327 didn't come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
Well, she's acceptable, Your Honor.
So, I mean, anything from My Cousin Vinny's great, but that's an example of really what not to do with voir dire. A lot of people on voir dire, they want to go after the expert on expertise. You know, hey, you're not qualified to render this opinion. I mean, almost 10 out of 10 times you're going to lose that fight because it doesn't take much to qualify. And so now whether they're going to give any weight to that testimony is a whole different question, but to qualify to give the opinion is not that hard. So my voir dires go more on to, hey, is this reliable? Have you have enough information to base an opinion on? That is where you're going to get more action, not on you're not worthy to be on the stand. Now, we're going to move now into admissibility issues. And so this is super important. Evidence Code 801, we should know this in our sleep. It's the most important rule when we're dealing with experts. And if we really understand this rule, we don't have problems with either cross or directive experts. Now, basically, we have to have testimony to be an expert opinion that's sufficiently beyond common experience. So this isn't something like, was this person drunk to you? Well, unfortunately, we have enough common experience with that lay people can render an opinion on that. So that's not necessarily a matter of expert opinion, but there has to be something beyond common experience. And then here's the catch. Would it assist the trier of fact? So I've won some on that to say, hey, what this person has to say is super interesting and I'd love to learn about it, but it has nothing to do with this case. It's not going to assist you, Your Honor, in hearing about this. And so sometimes we see that in where they'll want to call legal experts. And it's like, okay, well, certainly the person's qualified and they know things that people commonly don't, but it's not really going to assist the trier of fact to know what California law is, because the judge hopefully knows what that is. And if they don't, they can figure that out on their own. So the other part of it is that the testimony has to be based on matter that's perceived by the expert or more likely made known to them. So the perceived part would be like a site visit that an appraiser would do, going out there and saying, hey, you know, I actually went and visited this business and I kind of understood some things from doing so. But mostly it's made known to by providing records or telling them to make assumptions. And then those things that they did rely upon have to be reasonable for an expert to rely upon in forming the opinions. And that is the key, this last point: reasonable to rely upon, not necessarily admissible. So here's 801B in all of its glory. Whether or not admissible, an expert can rely on information that may be reasonably relied upon by an expert in forming that type of opinion, unless precluded by law from doing so. So we're going to kind of break this down. But this issue, so this issue here I was trying to highlight, but whether or not admissible debunks Sanchez, all the fears of Sanchez, I should say. And we're going to talk about that more, but that's an important part on Sanchez. You don't have to have admissible evidence for the expert to rely upon. It only has to be reasonable for the expert to rely upon. Now, we also want to make sure that this expert opinion is based on something good. And so this Jennings case is a good little one to have, where experts just throw out opinions. Oh yeah, I think this. Well, as the Jennings court said, that the opinion is only worth what it's based on. So when we're doing the direct, we want to bring out like, hey, what did you rely upon and why did you base your opinion on that? Why were those facts important to you? So we can understand this isn't speculation. It's not just a bare conclusion. It's a reasoned process.
So how do you get the expert's testimony into evidence? It's a pretty simple 4-step process. What matter were you engaged to render an opinion? What work did you perform to render your opinion? What is your opinion based on? What is your opinion? Just go through that litany and it's going to come out as long as your expert knows what they're doing. Of course, the difficulty is in the details of it, but stick to this pattern and you'll get what you want. Notice that they're all open-ended questions. None of them are leading. We'll discuss that more later on. So this is your formula for success.
Yeah, and you want the expert talking. So even though, and we'll talk a bit later, you can lead an expert, but you want this person talking, and that's why they're open-ended questions. And obviously this is a very simple script, but we want to draw all that information out there in these big open-ended questions. And I like to add in there, well, you know, oh, so yeah, I went and did all this work. I did a site visit, blah, blah, blah. Go back to that. Oh, you did a site visit? What's that? Oh, I went to the business. Why'd you do that? Oh, well, because I wanted to see what it looked like and this and this and that. Well, why was that important to you? Well, I don't think you can value something without looking at it very easily. Well, what'd you learn when you were there? Bah, bah, bah. It's just having a conversation, and it's just like 20 questions. Just keep drilling it out.
So this SARGON case dealing with USC and they were doing some work on dental implants with a company, and they went to they had a contract with them, and they worked with them for a certain period of time. They were not able to follow up, and they didn't market it. And the company sued USC and said if they had followed through on it, they would have sold so many dental implants and he would have made so much money. And Sargon introduced the court as a gatekeeper to keep out speculative expert testimony. I think the plaintiff had a damages expert who said, this is what my damages would have been. And the court didn't allow it in. So this gatekeeper concept applies to family law just as much as any other case and should be introduced at any given time. Next slide.
Yep.
So we want to keep out invalid and unreliable expert opinions. And that can be any kind of opinion applicable to a family law case. And generally, it may go to scientific opinions. And that's, or a speculative opinion relating to available jobs on the market, or a speculative opinion relating to the downturn of the economy, or the rise in the economy, or the stock market. Any kind of speculation by an expert may be a problem. So keep your eyes open for what is that expert going to testify on it, and can you make a Sargon objection to stop it right in its tracks? Sometimes that will happen and you can keep the expert out. I know it's happened to us in a case where our expert started testifying on whether Pereira or Van Camp should apply. Other side made an objection and was able to keep that out because it's a legal question. So be ready to keep out testimony that really an expert shouldn't be testifying on.
And I'll just note, we did make some last minute changes to the slides, and so it was a 1 or 2 out of order, but we'll repost up there in the share file at the end of the program, the updated latest and greatest version. Also, your MCLE certificates are on there for specialization in general MCLE credit, and the evaluation form if you have time to fill that out. Now, like I mentioned, in 801, it says the expert can rely upon any matter, whether admissible or not, that reasonably can be relied upon an expert in forming an opinion of that matter, unless precluded by law. And 803 is building on that, saying, well, the expert opinion shall be excluded if based upon a matter in whole or significant part that is not the proper basis for an opinion. This is a killer statute. And the reason why it's not may, it's shall. And so this is one to remember. And there are some traps in here that we're going to go through under the exclusionary rule where you may be able to get an opinion whacked, or your expert opinion may never see the light of the day because of it. So what's an improper basis? Mediation information. This is the one most likely we're going to get caught by, because like Peter said at the beginning, we settle our cases almost always through mediation, but many times with the forensic accountant there with reports in hand, usually marked, hopefully, for mediation purposes only on it. Now, so we have that. And those have been exchanged, but now they're in our file, and maybe we bring in new forensic accountant or other experts, and we turn over the file, and now that expert has been exposed to that information and maybe relying on it. And so I had this come up at a deposition where this was in the expert's file, and the other lawyer was trying to bait the expert into saying that she had relied upon this exhibit. Now, fortunately, she had not. But had she said, oh, yeah, I relied on that, we would have been cooked, because it was, that 803, if you're relying in whole or significantly on matter that can't properly be used, then your opinion is to be excluded. And 1119 is super powerful, that any information that's prepared for mediation cannot be used. So 1152 and 1154 of the evidence code I don't think it's that as strong, certainly as mediation confidentiality is, but there is some sacredness to there. And so could that be used also? So I'm careful with my experts to say, hey, whatever you learned or whatever you saw in settlement or mediation is not to be relied upon, not to be discussed or considered, and especially they'll try and do this. Oh, the other expert said X, Y, and Z, and now they're doing something different. No, we can't comment on that. That's we also have confidential information in a custody evaluation. Custody evaluations are confidential by operation of law. There's severe penalties for violating that. And so what happens when we bring in 733 experts? So we have the custody evaluator that's done it. We've now brought in a 733 expert to evaluate the evaluator. And most of us in practice have been just saying, here, new expert, here's the custody evaluation report. I don't think you can do that. Not without a stipulation saying that it's appropriate or court order allowing us to do that, because they're not a party to the case. The confidentiality rules say who gets to look at that report. That's the parties, that's the court, that's the attorneys. It doesn't say experts hired by. Now, maybe you can make an argument that, hey, close enough, there are agents or whatever, but look at ANCA, that was pretty harsh. So they interpreted these rules strictly with no love in that at all. And because of the importance of that information to keep it secret. Eavesdropping information. So this comes up because we have surveillance videos, we have computer files, we have emails, some things that maybe a party didn't rightfully have access to, but somehow got anyway and turned it over to the expert. And now if that was illegally obtained in violation of Penal Code Section 630, Family Code 2022 makes it illegal to use. It makes it inadmissible into evidence. And I would say 803 and 801 would make it an inadmissible opinion if it relied upon it. And so we want to be very careful about, hey, where'd you get this information from? Now, Family Code 2022, the only way that applies is if there's a Penal Code Section 630 at SEC violation, and that's really intercepting an email or phone call, not just viewing it improperly. So it's a strict standard that's often not met.
So you want to inquire about, did the expert rely or follow their professional standards? Why is this? Because if you don't do it, it's going to come out indirect and could blindside the experts. So accountants, AICPA, the California license have to follow certain rules. You can Google them. They're the SFVS 1 rules. Did they follow that? What about custody evaluators? American Psychological Association, AFCC, and as well as the California Rules of Court. Are they taking all the steps necessary in these rules? What about appraisers? Check out their license. Are there any guidelines that they must follow when they're doing a real estate appraiser or a business appraiser or a personal property appraisal? They must follow certain standards. You want to show how the expert complied. Don't wait for the cross. On cross, it can be very embarrassing, or the way it's phrased can be embarrassing to the expert. So you want to make sure that these are brought out. It also bolsters the expert's opinion, and again, it deflects the cross.
So it's super important for custody evaluators because their opinion, they're required by the California Rules of Court to follow procedure. They have to have a certain amount of education and training. And so that's all buried in the CRC. I actually went and culled all those requirements for a list of direct questions of a custody evaluator about 2 years ago. And it's pages of stuff. And anyone who needs that, let me know. I'm happy to share that. And so I was concerned that if I didn't get that information on the record, that the expert opinion could be subject to being stricken. So I went through And the other side, because I said, hey, I'll offer stipulation that the evaluator complied with the CRC in conducting the evaluation. Well, the other side said, no, I won't do that. So I started going through, and after I was at about page 2, they kind of tapped out and said, okay, I'll agree with that. But, you know, hey, if it's required by law, we have to lay the foundation or show that that was done.
Another key point is the expert can testify relating to the ultimate issue. Chris tells a story about when he was in trial and the opposing counsel kept on objecting that the expert was testifying on the ultimate issue. That is not objectionable. It can be done. Doesn't mean they can testify as to legal conclusions in the guise of an expert opinion. So there may be fine lines there, but that's their job to talk about, this is my opinion, and it could be something that it relates to the outcome of the case. I conclude that this is petitioner's separate property based on the tracing that I have just completed. Perfectly fine over the objection.
So the discovery violations, we have to be careful about. 2034 is a very technical process to follow. And if they weren't designated properly, or they didn't give the opinions that, or they weren't made available for deposition, change their opinion, that kind of thing, they could be excluded as an expert, or another deposition could be ordered, or they could be sanctioned. So we want to follow that to a T, understand that process of when can you demand the exchange of expert witness information, what do you have to put in there in the simultaneous exchange, how do you follow up with the other side when they haven't complied. So really it's a whole world right there, but super important.
So there used to be a difference between the California rule and the federal rule. California followed the general acceptance test for scientific evidence, which includes paternity tests, drug tests, doesn't include accounting testimony, child custody testimony. Basically, it's got to be scientific testimony. So let's move on to the next slide. Dauber introduced the judge as a gatekeeper to ensure the reliability of an expert opinion. And the questions are, was the opinion developed solely for litigation? Was it independently tested in the scientific community? Are there likely to be errors in the results? And that was basically the federal rule. Then along came, next slide.
Wasn't that? Yeah, we skipped it. We took a slide out, but the thing on this Dauber Kelly Fry is that it has to be scientific evidence. So it doesn't apply to an accountant or custody evaluator, in my opinion. This would be like a paternity test or a drug test, something that's being offered as scientific truth, and that's when Dauber Kelly Fry would apply. Things that a psychologist would say are really subjective. And even some of the opinions of a forensic or accountant are subjective. So we're talking about scientific evidence, I think, is when it comes into play. So now we're going to go into Sanchez. And, you know, really the Sanchez rule didn't change anything. The Sanchez decision, this was always the law, is that you can't put hearsay into evidence unless it's admissible. And so that's all Sanchez was saying. And experts are no different. Now, so an expert can rely upon inadmissible matter if it's reasonable for them to do so in rendering opinion. We know that from 801, but they just can't talk about it on direct. That's all Sanchez says. So basically on direct, they can say, hey, I looked at bank statements, or I talked to the child, and based on that information, I formed my opinion. There's nothing wrong with that. The opinion is what goes into evidence. The basis for their opinion is just explaining what they did. But it's the opinion that, hey, I think the move should be granted, or hey, I think the income available for support is X. That's what's getting into evidence. And we're not trying to move into evidence what they relied upon. And on direct, they can't talk about that out of court statements unless there's an independent hearsay exception for it. So also for opinions of others, you can rely on the opinion of others. We see this in custody evaluations. We see this in business valuations. We might bring in a compensation expert. We can do that. We can say, hey, expert, did you rely upon the opinion of this other expert in forming yours? Yes, I did consider that. I relied upon that, and here's my opinion. There's nothing wrong with that. But what they can't do is go in and talk about what that other expert told them on direct, because that is inadmissible hearsay. So, like I say, there's the Sanchez quote: "What they can't do is present as facts the content of testimonial hearsay statements." So the evaluator can't say, "Hey, I talked to the child told me X." They can't do that. I talked to the child, and based on what the child told me, this is my opinion. And if you want to get that stuff in, you're going to have an independent basis for doing so.
Of course, it always comes out on cross-examination, and there's no problem about it. What did the child say to you? If it's on cross, that's fine. But on direct, it can't come out. And so that's sort of the way it works. As Chris said, forensic accountants can rely on bank statements, but they cannot testify to the contents of those statements unless it's a business records exception. You got to make sure you get all your records into evidence if you want to ask them what they said. They can rely on bookkeeping records, but they can't say what they said. There may be a question if you haven't got the records in yet because of order of proof, your expert goes first. You can ask for conditional admissibility of those records, but you better be able to make good on your promise that those records will get in. The custody evaluator can rely on the statements of a child, can rely on statements of other experts, but they can't say what the child said except on cross when they're asked that. And that may come up, but you don't have to put the child on the stand to get the custody evaluator's report, custody evaluator's testimony into evidence.
So we talked a little bit about leading. We can lead an expert. So that's allowed, but we don't really want to do that because we want them to tell their story. So we don't want to have them just answering a series of yes or no questions. We want them talking and explaining and educating the court. So that carries a lot more weight. Now, sometimes you just have to lead, and that's just when the expert just basically falls apart on you, and now they're not giving you what you want, and so now you're going to extract that from them through leading questions. And so
it can happen
basically
at any time, right in the middle of your case, for whatever reason, the expert can't follow through, and you've got to take them to the next level, or they forgot, or something happens, and it always does. And you've got to be ready to lead them to the next phase until they catch their rhythm again. The judge could start asking them a question and get them off their game, but you have to be ready to jump in and take them to the next level if necessary.
So that's the problem. And we definitely, as we talked earlier about those mock examinations, it's important. A lot of that stuff's going to be revealed here. But what I've seen is this transformational effect of when the expert walks in the room, at least when we were able to be together, expert would walk in the room, see the judge, familiar face, see opposing counsel, familiar face, see the other side who's going to be impacted by this, and all of a sudden sheepishly saying, well, it could be this or could be that. But when last week when they're in their office, they're saying, this is outrageous. This is, clearly X. And now they're saying, well, it could be Y. So, that happens. And when it does, we got to basically cross-examine them and say, look, your report says this and this and this, and pull it out of them and get it. And it's terrible. But if you have to, you have to. Admitting the report, I don't ever do that. The other side wants to get my report in, fine, but I don't see myself agreeing to putting somebody else's report in. We'll mark it for identification so the judge can look at it and agree, yeah, you can look at this thing. But going into evidence, I'm very concerned about that because, like Garrett says, in for a penny, in for a pound. And there's a lot of stuff in some of these things. So You know, hey, if it's innocuous, okay, fine, but I would be very cautious about admitting a report. Okay, we're running towards the end here. I just wanted to talk about some other programs we're giving. We've put on a lot because we're having fun with this, but next Monday I'm doing a program on characterization transmutation issues for ACFLS. It's a free program, so if you're an ACFLS member, please go check your email there. If you're not a member, let me know. I will get you a link, and happy for you to join us. It's going to be a great program, and really building on this Brace case where I had the opportunity to argue before the California Supreme Court in May on characterization. So I love this topic, and we spent some time talking about it. We're also going to be doing one on businesses and economic crisis as an in-house seminar. We're going to be doing one on spousal support, July 27th. Peter's going to be doing one for ACFLS on death and divorce with an estate planner. That's a great program. Again, being offered free by ACFLS. So go ahead and register for that. If you're not a member, let me know. I will send you the link. And then finally, we're doing one on privacy issues in divorce. All those programs are listed on our website on the seminars page, and there should be links right there if you want to just go there and you could sign up for those. All of those 5 programs are free. I hope you can join us for it. So we've talked about the importance of experts. They are such a critical part of our case. They tell a very powerful story when they're prepared and coached properly to do so. But it's our job to get that story out of them and to get it into evidence. And to get it into evidence, we need to know the rules of evidence. Now, if you could do us a favor, at the end of this program, we're going to send you a link, and you might another email, maybe tomorrow or something like that, with where you can find this on YouTube. And there's going to be a link on there for some Google reviews. We're trying to collect these reviews. They're so powerful to us, and it would mean a lot to us if you could take a moment and go on there and give us a review. If we're not connected up on LinkedIn, if you could do that too. Find me or Peter on LinkedIn and chat up with us. Our emails are there too. We're always just happy to be with you. There's so many friends on here. Just really happy to see you all here today. Peter, any closing remarks?
Know the rules of evidence. Tell the story. The expert will persuade the judge. Thank you for attending.
Thanks.